Hello everyone! Welcome to Immigration Basics with Attorney Mustafa Sitin. This is a new series where I'll be covering popular immigration topics by relying years of my experience as an immigration lawyer. Consider this as a consultation where I'm breaking down certain topics, everything basically you need to know before you take a step to make a decision, to make an informed decision. Today's topic is H-1B. H-1B is probably one of the most common visa types that's been around for a very long time, and it's been very popular, very common for a business immigration-related immigration journey. First thing we should make clear is that despite being quite popular, H-1B visas are limited. There are a certain number of visas available each year. The only exception to this is certain nonprofits and higher education institutions. These are usually universities or hospitals around the country. They are not subject to this restriction. In other words, they can hire someone, they can start this H-1B process without being subject to the numerical limitations, and maybe more importantly, without waiting for the lottery, without waiting for within certain time periods. Everyone else is subject to a limited number of visas, and every employer must, during a certain time of the year, register the visa petition they will be considering to file for a specific employee. So what are the requirements for that? I'm going to first start by explaining the process, the timeline, that is applicable to most common employers, the for-profit employers, the ones that don't fall under this exception. Understanding the timeline, I'm hoping more employers and employees are better informed before they make a decision, and I'm hoping to shed some light on where we come in, what we do specifically for employers and employees. The process starts with an online account. This timeline, before March, around March every year, employers are expected to first create an online account. And then the next step is registration start period. Usually registrations are around within March. They start early March and they end at the end of the March. And within this period, employers create an account, and based on a single registration for a specific individual, based on that passport data of that individual, by paying a registration fee, they register someone for a lottery. And this lottery is electronic. Registration periods usually around early April. Lottery results are out and applications start. Where do we come into play here? We help with account creation, and maybe more importantly, with an assessment of the potential application the employer will be filing. We look into the position offered. We make a preliminary assessment to make sure that application, if the lottery is selected, that registration is selected, will be successful when we file it on behalf of an employer. It's important to note that we represent the employer. We are not, employees are directly not our clients, but they are involved in the process, because we make sure when filing the application, they are eligible for this type of visa. Applications start around early April after the lottery results are out, and there is a petition submission deadline. There's a mistake here. This is not supposed to be April. Let me correct that. It's supposed to be June. Within this period, applications are prepared and filed, and usually decided in a timely manner, and the earliest job start date is the beginning of the fiscal year, which is usually October 1st of that year, specific year. That means if the petition is approved, the earliest start date an employee can start for a job like this is October 1st. Let's talk about what it takes to prepare a successful petition. Over time, when representing employers and employees, we created a checklist. We cover certain basics, we ask certain questions to make sure the petition will be approved. We call this, eligibility conditions, requirements. So what are these? First of all, there is requirements regarding the position, objective requirements, and requirements about the employer, and there are requirements that apply to the employee. The most important requirement is the position for H-1B must be a specialty occupation. It cannot be just any type of job, unfortunately. One thing to put this in context, an example I can give is usually an H-1B is not a blue-collar job. In other words, you don't have a lot of similarly situated employees doing similar type of work. H-1Bs are usually more specified. It involves a professional degree, usually a bachelor's degree, or a certain amount of experience in relevant field. It will be up to the employer to decide what kind of relevant experience they are requiring. The job offer must be a legitimate one. And if the position involves a license, the employee must be in a position to secure that license. Sometimes the license is required at the beginning when the petition is being filed, or sometimes the license can be obtained really short period after the petition is approved. We have done one of those. There's an exception there. So if there is a genuine employer-employee relationship, the employee is willing to sponsor, and the employee does this by preparing and filing the Form I-129. This is where we come into play. We prepare the application package, we prepare all the necessary documentation, and then we send it. And when the application is approved, the employee can start working around October 1st. It could be later, but you get the gist. One of the most important aspects is it has to do with the salary. Because believe me, when it comes to an employer's perspective, probably one of the most important things is how much they will be paying for the specific employee. Now, the law says H-1B positions cannot be undercutting the U.S. labor workforce. In other words, there must be prevailing wage being paid for a specific location for that specific job. Otherwise, the application is not going to be approved. So one thing critical here is where our expertise comes into play. What type of job you're dealing with? Is it typical enough to rely on SOC codes? Department of Labor has these SOC codes, which is Standard Occupational Classification, and there are wage data, statistics available that we can rely on. Otherwise, if what employer wants to do, kind of job they want to offer, doesn't fall under one of these categories, then there has to be a prevailing wage determination filing, which complicates things a little bit. Considering how strict the timeline is, it's a good idea to make this determination beforehand so you can file the determination application faster, if it's necessary. Okay, so other things to ask, usually not common, but if there's a collective bargaining agreement, that will come into play. Or if the job is new, the position is new within the organization, or has it been held by someone else before, and what is the expected work location? Because that comes into play when deciding the expected work location, comes into play when deciding the salary and other conditions that apply after someone secures an H-1B approval. Now, let's talk about the employee. What are the requirements for an employee? First of all, the employee must be eligible for this visa. In other words, not be inadmissible for general immigration purposes. So that's a term of art, but the most common questions we ask to make sure there are no complications is the beneficiary or their family member, the dependents will also be relying on the main petitioner, like spouse or children. They will be derivatives. Have they ever been in removal proceedings? Have they ever been arrested? Have they ever been denied a visa to the United States? Or denied admission to the United States? These are the relevant questions we ask to make sure. Another important practical aspect is if the beneficiary and their family members are status or not. Because if they are in status, they can secure the visa approval, without leaving the country. Otherwise, they would have to go through consular processing and get a visa stamp. Now, this process is fairly procedural and simple, but it's important to make sure so that the individual candidate can safely travel and plan accordingly. And you get that right, exactly. The travel is only possible after getting a visa stamp. So at some point, even if you secure the H-1B visa by change of status, you will have to get an appointment with a consulate and get your visa stamped, get your passport stamped to be able to safely travel. Now, what happens after the visa is approved and the relationship starts? Duration of the H-1B is limited, but it's an ample amount of time for the purposes of securing a sponsorship, which would lead to a green card. So it is initially granted for 3 years, but it can be extended for another 3 years, 3 plus 3, and this is a very convenient time frame to secure other type of employment. Within this time frame, the employers get to know the employee. And usually a certain amount of time into the employment relationship, the employer is comfortable enough to offer the employee a green card. That usually involves something we call the perm. In other words, labor certification. This is filed with Department of Labor. There will be another video about this, but it will be, depending on the amount of backlog with the Department of Labor, it will probably take nothing less than two years for the perm. So H-1B is a very suitable, very practical way to secure a green card through that employment. And another thing is, H-1B is dual intent, which means your visa will not be hurt if you try to secure immigration, a sponsorship. Another good thing about H-1B, making it very common, is if you qualify for the cap, if you win the lottery initially, you can change employers. So if your relationship with an employer finishes, someone else can hire you. They don't have to register you again. That 3 + 3 years of time frame that you get, you can use with any employer. Now, same requirements will apply when a transfer H-1B visa petition is being filed, but these are the dynamics that it allows for a visa like H-1B to be a very common visa type that leads to immigration, business immigration for the candidate. And it's convenient for the employers as well, because they get to tap into a workforce that is not within the US. Bring in foreign talent, usually those who study in the US, graduating from schools in the US. These are the basics we wanted to cover. If you have any questions about these, feel free to comment and subscribe for similarly situated videos that we'll be sharing soon. If you have any questions, our contact information is there. You can reach out to us. We'll be more than happy to guide you through the immigration process, both employer and employee wise. Thank you for watching and keep in touch.